are you aware that you are on the Brady List?
I am, yes.
The court has found that you've sustained an allegation of departing from the truth. Is that correct?
No.
It's not correct?
No, or I wouldn't have a job anymore.
So just to clarify, your IA file states that you received a letter of reprimand departing from the truth.
Yes. So that small part of it did sustain that I departed from the truth.
Three People versus Ming. Miss Ming is present. If I can get entries, please.
This is Andrew Hoffman. He is Student Practice Act, but he's going to be handling the hearing. It will be under my bar number.
Good afternoon, Officer Hutchinson. Could you introduce yourself and spell your name for the record, please?
I am Officer Andrew Hutchinson. I was driving eastbound in the 3300 block of West Colorado Avenue. I observed Miss Ming's vehicle drive past me. When it drove past me, the windshield was extremely cracked and appeared very hard to see out of, like something had fallen on it. And Miss Ming gave me a very uneasy, nervous look. From there, she pulled into a car wash near where I had first spotted her, parked her vehicle, and then exited and began to walk northbound across West Colorado Avenue.
So Exhibit A is admitted without objection from the people. You can go ahead and play it as you would like.
Leave it first.
20 seconds. Yeah.
Okay.
Yeah.
That is on.
Now, it appears you were in the middle of a conversation, correct?
I mean, I wasn't speaking.
Okay.
Now, defense is arguing that she was in mid-sentence when you turned on the body cam. Can you explain if that's correct?
I mean, she is in mid-sentence, but I was not interacting with her. That was Deputy the Baron interacting with her.
Did you use lights and sirens when you saw these traffic infractions?
No.
And you did not contact her at her vehicle? Or did you contact her at her vehicle?
No, I did not.
Okay. And you testified on cross that there was a meth pipe. Is that correct?
Yes.
And you wrote a report on this issue, correct?
Correct.
And would you say this report would be a fair and accurate representation of what happened?
Yes.
Okay. When Corporal Schulke described the glass pipe, you believed it was a marijuana pipe in your report. Is that correct?
Yes.
Okay. Yeah. And you did not personally observe this marijuana pipe?
I did not.
Okay. No further questions.
Hello, can you tell us your name and what your position is?
Yes, I'm Corporal Jeffrey Schulke with the Manitou Springs Police Department.
Did you look through the contents of the vehicle?
From the outside, yes.
What did you see?
I observed a marijuana pipe in plain view with burnt residue in the bowl.
What did you do at this point?
I then started a probable cause search of the vehicle.
And at what moment did you have that initial interaction with the defendant?
I'm not sure exactly. I haven't reviewed my body cam, but it would have been at some point when they had detained her and walked her back to the scene.
I'm sorry, I'm going to butcher your name, but good afternoon, Officer Schulke.
Nailed it.
Awesome. Great. Well, nice to meet you. And just to be clear, Miss Ming was not in the vehicle at the time, correct?
Correct.
And you leaned in through the open window and saw a marijuana pipe. Is that correct?
I know I saw it from the passenger side through the open window. I don't know if I leaned in there or not.
Okay. They played at 48 seconds. We're looking at 20 seconds earlier.
Okay.
Right before the probable cause search begins.
Okay. I'm sorry. Can you replay that?
Yeah.
1 second. Just for the record, that stops at 42.
Okay. Thank you.
So as you can see in that body worn camera, you first reach your arm into the window through the open window. Did you see that?
Yes.
Yeah. Now you took photos of this event, correct?
Yes.
And you understand the importance of taking accurate photos.
Yes.
And why it's so important to document everything that happens, correct?
Yes.
And to not disturb the investigation scene before you take these photos, correct?
Ideally.
Yes. So I'm going to, well, first I'll show the people, but may I approach with defense exhibit B?
Yes, sir. Mr. Gribian, are you stipulating to the admission of this photo?
That's fine, Your Honor.
Okay. Go ahead and approach it.
So you saw exhibit B, correct?
Yes.
And you saw that it was up against the edge of the car door, correct?
Yes.
And so in order to see that, you would have needed to have almost a straight down angle to see this marijuana pipe.
Looks that way.
So you would have had to lean into the car.
Most likely.
Yes, okay. And may I publish this to the judge?
Yes, sir, please.
No further questions.
Okay, thank you. Any redirect, Mr. Gribian?
No, Your Honor.
Testimony you're about to give is the truth, the whole truth, and nothing but the truth. Thank you. Please take a seat. The chair doesn't move, but the microphone does. Make yourself comfortable. Pull the microphone close. Mr. Gribian, when you're ready.
Hello, can you tell us your name and your role?
Yeah, Deputy Daniel LeBaron, Lebaron. I'm currently assigned to the Patrol Division for the El Paso County Sheriff's Office.
Did you respond to a call for service on May 31st, 2025, around 1 a.m.?
I did, yes.
And what was that call for?
I was currently on patrol as a DUI enforcement vehicle, and I had been notified by Sergeant Schilke that Officer Hutchinson had been following a vehicle, and they had the driver had ditched it at a car wash and then gotten out and was walking towards some hotel in the area. So I responded just, again, I'm driving around looking for DUIs, basically.
So you never saw this vehicle drive?
I did not know.
Okay. What did you do after you parked?
After I parked, that's when I went around the backside of the hotels trying to cut her off to make sure she didn't escape.
Based off of what information did you initially contact her for?
I'd been told that she'd been erratically driving or she had done something, and then just vehicles unregistered, and then her ditching it at the car wash and then quickly exiting and trying to avoid us. That was the reason why I went out and backed up Officer Hutchinson then.
Prior to getting this information, was the defendant detained?
Yes, she was.
Based off of, what was the basis for that detention?
The unregistered vehicle, and then just, again, the suspicion based on her quickly avoiding or quickly abandoning that vehicle at the car wash and walking across the street. And Miss Ming, for this whole time that we've been talking to her, was speaking pretty rapidly. She was defensive. She was just a lot of kind of that energetic demeanor that, despite her physical tired appearance, made me suspect that she was under the influence. And I approached her then after Officer Hutchinson had already stopped her. And that's why there was a delay in me starting up my body cam, because with our body cams, generally they're synced to our vehicles. But since my lights weren't on, it didn't automatically turn on when I exited the vehicle. So, yeah. He initially stopped her, and then I came in maybe a few seconds later.
To break down what you saw, to make it clear, you did not see her drive.
I did not know.
Now, you also testified on direct that you circled around the entire motel hotel area because you were afraid she was going to run. Is that correct?
Yes.
Now, this is nowhere in your report. Are you aware of that?
Correct.
Correct. Okay. And you understand the importance of keeping accurate reports.
Yeah.
You understand the importance of documenting every step of the process?
To an extent, yes.
Yes, because it's important to keep accurate reports
Correct.
for judicial efficiency,
Correct.
just for the interest of justice.
Yes.
And you did not keep an accurate report in this case.
I put in the pertinent information, yes.
Okay, but you left out this circling around the vehicle, correct?
That wasn't pertinent.
You didn't find that pertinent. Okay. Now, in your report, when you first contacted her, you claim you saw her erratically. Or acting erratically. Sorry, I skipped an important word.
So are you talking about what I was told by the officers who had seen her driving, or were you talking about her rapid speech, her energetic demeanor after I approached her?
In your report, you write, upon contacting Miss Ming, she was moving erratically, talking rapidly and defensively.
Yes,
Now this is not in your body worn camera.
it should be. Yes,
It should be? Okay. Is this a fair and accurate representation of your body worn camera?
the image. Yes, it's my flashlight. It's my hand.
Okay. Thank you.
Without objection, the Exhibit C is admitted. You can play whatever relevant portions. I would just ask again for the recorded record if you could use timestamps.
Right at the very beginning.
We'll start right at the beginning, right when it turns on.
Okay.
What are their names? Dr. Bowen?
Yeah.
Yes.
You smell like fentanyl.
I smell it there. So if it's not true, then I can like see.
Yeah, cool.
Now in that moment, you still claim you saw her acting erratically. Is that correct?
Not that specific moment.
Not in that specific moment. But that's when your body worn camera first turned on, correct?
It is, yes.
Okay. And you also told her that you smell like fentanyl. Is that correct?
I did, yes.
Now fentanyl is an odorless drug.
It is, yes.
It is. Okay. Okay. And at this point, you then step around and you start smelling the area. Is that correct?
I do, yes.
Because I believe in your report, you say that the smell of fentanyl is coming from somewhere else. Is that correct?
Fentanyl, yes.
Yes. Okay. Burnt fentanyl. And what does burnt fentanyl smell like?
I mean, you have to be around it to be able to smell like, it's like, I always kind of explain it like a baker can kind of tell what type of bread he's baking, from sourdough to rye, just based on his experience being around those recipes, those different ingredients. He can then say, yeah, I can smell sourdough bread, right? It's distinguishable to those that have been around it enough times. It's this burnt, acrid taste or smell. It kind of smells like a skunk, but it's a little bit more pungent than a skunk to me.
Okay. So you would be able to identify it, correct?
Correct. Yes.
I would not be able to identify it.
I don't know your drug history.
Okay. Okay. A layperson would not be able to identify is what you're saying.
That's speculation.
Sorry.
No
Okay.
idea what a layperson could testify to. If you can ask him, he's a fact witness. You
Okay.
can ask him about facts, not speculation.
Okay. And when you ended up searching this vehicle, you found no fentanyl, correct?
I didn't know.
It's about your ability to testify reliably.
Go ahead.
Okay.
So I'm counsel, if you can ask questions and not just put out those,
Okay.
I want to talk to you about why I shouldn't believe you. That is not an appropriate way to address a witness in this courtroom. Am I clear?
Okay. Yeah. Are you familiar with the Brady List?
I am, yes.
And are you aware that you are on the Brady List?
I am, yes.
And are you aware that you're on the Brady List because, we'll go through this in more detail, but because Judge Ankeny in El Paso County found you incredible as a witness?
Yes,
And this triggered an IA investigation.
it did, yes.
And the board determined that this was because you had an unsatisfactory work performance.
Correct.
They claimed you did not prepare properly.
For court, yes.
Yeah. Some of your other officers, they made their own concerns, correct?
I don't know what you're talking about.
Oh, sorry. I believe in your IA report, Sergeant Hubble expressed concern about your ability to ever walk into a fourth judicial courtroom and be seen as a credible witness.
He did, yes.
He did. Okay. And Commander Ray Bernier stated that you lost your stature as a peace officer to provide truthful testimony, not because your actions were on willful misconduct, but based on sheer incompetence.
I think that was prior to the dab finding.
Okay. But that was something that came up as part of the IA investigation.
That was an opinion, yeah.
And you have worked on other drug cases before.
I've worked on many drug cases before.
Okay. You have made drug stops.
I have.
And you have said before that you like to leave drugs in the car so you can get probable cause for the next guy.
Your Honor, I would object to this line of questioning.
Sustained.
This is,
Move on. None of what you've done is absolutely relevant. I don't care whether his boss thinks he doesn't prepare. That is not going to truthfulness.
This is speaking to his credit.
Stop interrupting me. The fact that Judge Ankeny found him to be not credible, I don't know what she was presented. I have a lot of respect for Judge Ankeny, but I can't just accept her opinion without you presenting me with anything. You've told me that he didn't prepare for court. He didn't watch his body cam. None of that goes to credibility. So all of that is absolutely irrelevant. All you're doing is wasting time. You're trying to drag him through the mud, and that's not appropriate. If you want to ask questions that have to do with his honesty, truthfulness, you're welcome to, but you're wasting your time.
It is true in this IA finding that the court has found that you've sustained an allegation of departing from the truth. Is that correct?
No,
It's not correct?
no, I wouldn't have a job anymore.
Your Honor, I would object just simply. I think at this point, counsel has expressed enough positioning regarding the veracity and honesty of this witness. What we're going into now is essentially details of other findings by other judges without really having testimony or exhibits. And my concern is that we are prejudicing this witness by going into topics that essentially are creating their own mini hearings at this point.
So at this point, Mr. Hoffman is just asked to approach. He hasn't asked any questions, so the court will allow him to approach. Go ahead, sir.
Okay.
So April is the culmination of everything. This is a month prior, what continued.
So it's not appropriate for you guys to discuss this. He's just showing you a document. He'll go back to the podium and ask you additional questions. He's just giving you a chance to view it first.
Certainly.
So just to clarify, your IA file states that you received a letter of reprimand departing from the truth.
Your Honor, I would just renew my objection based on my prior record.
Overruled. Go ahead, sir.
Yes, so that small part of it did sustain that I departed from the truth.
Okay. No further questions.
Mr. Grubin, any redirect?
Officer, how long have you been employed?
13 years now?
Are you still employed?
I am, yes.
You still receive training?
As far as what?
Is there any continuing training that you receive?
I constantly receive training yearly.
And that's all for our
Okay, thank you. Either side object to this witness being excused?
No objection, Your Honor.
no objection.
Okay, thank you, sir. You can step down. You're free to go. Mr. Grubin?
No further witnesses, Your Honor.
At every point of this investigation up until the agreed upon search, there are significant Fourth Amendment concerns. We have heard the facts. I will provide the legal analysis, and I believe that the only just ruling for this court is suppression under the exclusionary rule. It demands a specific and articulable basis in fact for suspecting that criminal activity has occurred, is taking place, or is about to take place. A funny look, a broken windshield, and pulling into an abandoned car wash is not a specific and articulable basis in fact that criminal activity has occurred. He does not have probable cause to make this search. He does not have reasonable suspicion to make this search. New York v. Class articulates that even a momentary intrusion into a vehicle is a search.
Mr. Hoffman, I apologize. Can you give me the site for that last case?
Yes, New York v. Class 475 US 106.
Okay, I'm sorry. Go ahead.
Thank you.
And then when you combine that with her abandoning the vehicle and attempting to walk away from Officer Hutchinson, that furthers reasonable suspicion. And then when Officer Schulke sees the marijuana plain view pipe, that's further evidence of DUI. But when he sees the missing license plates, that's already a crime. So at this point, there is reasonable suspicion and probable cause?
He testified, the court did find him to be credible with respect to most of his testimony. However, the court does not find him credible with respect to the body cam. He testified that when he walked up, Deputy LeBaron was already speaking to her, and that's the reason that the video kind of cuts in right in the middle of a conversation. That didn't really seem to make sense because as I was watching it, the court heard Deputy Hutchins engaging in conversation. When they walked up, Ms. Ming was responding to a question. Deputy LeBaron said that, and I'll go into him in a moment, but he said that he circled around the building because he was afraid that Ms. Ming was going to try and get away, and that he walked up when when Officer Hutchinson was already in contact with her. So the court can't find him to be credible that the conversation that is occurring when the body cam is turned on is with Deputy LeBaron. On cross-examination, the court was able to view the video. It is clear the officer reached into the vehicle. Exhibit B shows how close the pipe was to the door. The court doesn't believe that the officer could have seen it from outside of the door. Maybe there's an argument that if he had gone around to the other side, but the court then heard from Deputy LeBaron. He was called to investigate a DUI. A suspected DUI. He never saw the vehicle in motion. He never activated his emergency equipment. He talked about going around the back of the Swiss Chalet Hotel because he was afraid that the defendant, Ms. Ming, was going to try and run. There's no indication of her running whatsoever, but that he approached and the Officer Hutchinson was with Ms. Ming. He was asked if she was Mirandized. He said he didn't do it, but he believed that Ms. Ming understood after Corporal Schulke explained. There was some cross-examination. The court does accept that he was on the Brady List. So an individual's opinion, you can call that person and say, do they have a reputation for untruthfulness? You can't just say, Joe Blow out there thinks you're untruthful. That's not appropriate. So that's the reason that the court can't put any weight on that. All of your cross-examination about the IA file, the fact that he was found to have not prepped, is not something that doesn't go to truthfulness, but the court did also accept the fact that there is a letter in his IA file stating that he departed from the truth. The video starts in the middle of a conversation. He tried to say that it was Deputy LeBaron. The court actually finds Deputy LeBaron a little more credible on that issue, so the court does find that there was a violation of the body-worn camera statute. There was a contact with the defendant. It was not recorded. The court hasn't been presented with any reason why it wasn't recorded. I've been presented with no evidence about malfunction or anything like that. Parties seem to have missed 42.4.201, obstruction of a windshield. If your window is bashed out so that 60 to 70% of it is unviewable, that's a violation. That's probable cause. They could have stopped her. They could have turned on their emergency equipment. They could have pulled her over and issued her a ticket. The court had a chance to review the New York versus Class. I was not aware of that case. But the court, in that case, the U.S. Supreme Court found that just sticking your arm into a vehicle is a seizure. Therefore, we have a search. Him leaning his head in there, reaching his arm in there is a search. At that point, there was no probable cause. There was no reasonable suspicion. At this point, the court is finding that the detention was reasonable for investigation of a violation of the obstructed windshield as well as a driving an unregistered vehicle. The court doesn't find any probable cause that there would be evidence of those crimes in the vehicle. So the court believes that that is an illegal search. The problem with that is that set the impetus for everything else. Cannot rely on illegally obtained evidence. So the court is going to find that viewing the pipe was illegally obtained evidence. Therefore, the court has to suppress that and look at the probable cause. The court finds no probable cause to go through and search the vehicle. Between that, the odor, and the roadsides, the court is going to find that there was probable cause to arrest for the driving under the influence. All of the evidence that was contained in the vehicle, that means the marijuana pipe is going to be suppressed. Both the containers of methamphetamine. Also, I think there was a broken meth pipe. All of that is going to be suppressed as fruits of an illegal search. The court is going to allow testimony regarding the roadsides. The court does believe that those were valid and voluntary. So, Mr. Hoffman, any request for further findings or rulings?
May we have the permissive inference for the body-worn camera, instruction for the body-worn camera violation?
We'll talk about that when we get ready for trial, but the court is finding a violation. We'll figure out what the remedy for that is.